This is a relatively difficult case, believe it or not. On the face of it, it seems simple. But as a backdrop here, there's all sorts of animosity between the family, which I can't begin to cure. What there is at the centre of it, though, is a family that have broken down over money, and in particular over a will. Now, just to be clear, Brenda, I see that your dad kept a record, and I believe he did. And I've also had the opportunity to read all of your submissions, which support the fact, in addition to what John's come to say today, that your dad did keep a record of who borrowed money and who lent him money. And I also find, without any difficulty, it seems to me, that he may very well have considered that Rachel owed him money when he died, which is why he decided not to make a disposal to her after he died in his will.
Okay.
And in the circumstances, he was entitled to do that, and that may have been the reason why Rachel was left with nothing, and I accept that, and I accept what you say about that. That doesn't assist me with Rachel's case, where, in effect, she says, many, many years before Dad passed, for reasons which I accept and believe, she gave him £1,000 to protect, to keep separately from any other funds. But in the circumstances, that money was held on trust by your father, separate from any money that he was entitled to dispose of in his estate. Do you understand that? In the circumstances, I do find it credible, and I do find it, on the balance of probabilities, more probable than not, that that money was handed over and held in separate trust. And therefore it is, whether it's just or not, whether it's right, returnable to Rachel, and that money is owed to her. So to that extent, this court awards Rachel £1,000. You haven't won anything.
No.
Because it seems to me that whatever happens here, you've lost, all of you've lost, a family. Rather more valuable than £1,000.
No.
That's the award of this court.
Thank you.